Hello, my name is Levitt Brown. I am a student at William Woods University. I am presenting to you today a video presentation of a legal case. I will be presenting the facts of the case, arguments on both sides of the case, the court findings, and implications for the athletic activity administrator. First, the facts. This case is Clinton versus Gettysburg College, this court case is held in the U.S. Courts of Appeals in the Third Circuit Court. The facts are, this appeal arises out of a post-judgment order in the United States District Court for the Middle District, Pennsylvania, which granted summary judgment to the appellant Gettysburg College. The district court determined that Gettysburg College had no legal duty to implement preventive measures assuring prompt assistance and treatment in the event of one of its athletes suffering from cardiac arrest, while engaged in a school-supervised intercollegiate athletic activity. It also determined that the school acted reasonably and therefore did not breach any duty owed to Drew following his collapse, and determined that the college is entitled to immunity under the Good Samaritan Act. This underlying litigation between Susan W. Clinton and Richard P. Clinton derived from the death of their 20-year-old son, Drew, who was recruited by Gettysburg College to participate on a Division III intercollegiate fall lacrosse team. In September 1988, the college employed two full-time athletic trainers, Joseph Denali and Gareth Beiser. Both men were certified by the National Athletics Trainers Association, which requires CPR certification and standard first aid. In addition, 12 student trainers participated in the college's sports program, all of whom were not certified in CPR. On September 16, 1988, Drew participated in a practice that was supervised by coaches Jock and Anderson. It was held on the softball fields outside Musselman Stadium. No trainers or student trainers were present. Neither coach had certification in CPR, and neither coach had a radio on the practice field. The nearest telephone was almost 250 yards away from Musselman Stadium. The September 16, 1988 practice began at about 3:15 p.m. with a light workout. Drew was participating in one of the drills when he suffered a cardiac arrest. One team member testified that by the time the coaches arrived, Drew was really blue. According to the college, the coaches acted in accordance with the school's emergency plan by first assessing Drew's condition, then dispatching players to get a trainer. Later in the incident, trainer Tracy Moore arrived on location, and she felt that he was breathing, so what she did, she just monitored Drew and called for an ambulance. The family's position is that neither the school nor the coaches or trainer acted appropriately considering this situation. Denali arrived on location and saw that Drew was not breathing and started CPR with the help of a student band member who was certified as an emergency medical technician who had just happened by chance to be on the scene. The two performed CPR until the ambulance arrived at approximately 4:15 p.m. Drew was pronounced dead at 4:58 p.m. Prior to his collapse in January of 1988, Drew was cleared by both college and family physician to participate in sports. The issues. The clinics are presenting three general issues on appeal. They first argue that the district court erred in determining that the college had no legal duty to implement preventive measures, assuring prompt assistance and treatment in the event one of its student athletes suffered cardiac arrest while engaged in school-supervised intercollegiate activities. Second, the clinics maintain that the district court erred in determining that the actions of the school employees following Drew's collapse were reasonable and that the college did not breach any duty of care. Finally, the clinics argue that the district court erred in determining that both Tracy Moore and the college were entitled to immunity under the Pennsylvania Good Samaritan Act. In the decision-making process, the federal courts determined that they would use what they call diversity jurisdiction, which must apply the substantiated law of the state whose laws govern the action. The parties agreed that Pennsylvania laws applies to the present dispute. Also, in the cases where the state's highest court has not considered the precise question to be answered, the federal court is called upon to do so. And that is precisely what happened in this case. Because the Supreme Court of Pennsylvania has not addressed precise issues raised by the clinics, the federal court must predict how the Supreme Court will rule on these questions. So in this case, the federal court will predict how the Supreme Court would rule and then render opinion back down to the district court. The Supreme Court of Pennsylvania states that duty given in any situation is predicated on the relationship existing between parties at the relevant time. The clinics argue that there was a special relationship between their son and the school because, after all, they had recruited their son, and that they should be responsible for their son during practices. The clinics argue also that the Supreme Court has not addressed this precise issue. It would conclude that a college or university owes a duty to its intercollegiate athletes to provide preventive measures in the event of a medical emergency. The appeal court ruled that it predicts that the Supreme Court will find that a special relationship existed between the college and Drew in his capacity as a school athlete, and that his medical emergency was within a foreseeable class of unfortunate events that could occur from participation in intercollegiate contact sports, which the Supreme Court recognizes as a duty and affords some sort of protection, and that the college must strengthen its policy in adopting reasonable preventive measures under the facts of the case. The college owed a duty to Drew to have reasonable measures in place at the practice on September 16, 1988. The college also argues that it is entitled to immunity because of the persons within the terms of the statute can be a corporation. In general, Pennsylvania statutory law defines a person as including corporations. Section 8332, however, requires a person seeking immunity to hold certification in an approved first aid, advanced life-saving, or basic life-saving course. The court reasoned that the Pennsylvania General Assembly intended that corporations could achieve requisite certification and receive immunity. However, these measures can only be taken by a natural person. Therefore, the court rejected the college's argument and predicts that the Supreme Court of Pennsylvania will not hold that a corporation is entitled to immunity under the Pennsylvania Good Samaritan law. The decision: the district court's holding that the college's duty of care to Drew as an intercollegiate athlete did not include, prior to his collapse, a duty to provide prompt emergency medical service. He was engaged in a school athletic activity and will be reversed. So they reversed that decision. They also stated that the district court's holding that the college acted reasonably and therefore did not breach any duty owed to Drew following his collapse will likewise be reversed. Also, the court reversed the district court's conclusion that the college is entitled to immunity under the Good Samaritan law. So in this case, the clinics got exactly what they asked for, and what happens in this case that the federal court will send down their opinion to the district court. Some of the implications for the athletic director and activity administrator are obvious. This is a case where the athletic director could be possibly relieved of his job. Also, he could be named, he or she could be named in litigations, and there will undoubtedly be face scrutiny for not having an emergency plan in place from the Board of Education, the media, and the community. Thank you.